and welcome. UVA Speaks is a podcast of Lifetime Learning, a division of the Office of Engagement at the University of Virginia. Lifetime Learning brings the knowledge and expertise of UVA's faculty to the university's alumni, friends, and families. My name is Susan Lynch, and I am the Associate Director of Lifetime Learning at the University of Virginia's Office of Engagement. This podcast features Crystal Shin, a professor of law at the University of Virginia School of Law and director of the Holistic Youth Defense Clinic. She joined the law school in 2017 and served as the first full-time faculty director of the program in law and public service until 2020. Before entering academia, Shin was an attorney for the JustChildren Program of the Legal Aid Justice Center, where she provided legal representation to children and families in the areas of special education, school discipline, juvenile justice, and immigration. In this podcast, Professor Shin will talk with us about the work that she and her students do at the Holistic Youth Defense Clinic at UVA's Law School. So thank you, Professor, for speaking with me today.
Thank you so much for this kind invitation.
Great. So thank you so much. First, can you tell us about the Holistic Youth Defense Clinic, and help us understand what a clinic is within a law school?
Absolutely. And I'll start by answering the second question first to give an overview to folks. So clinics give law students an opportunity to practice law under the close supervision of a clinical faculty member or a supervising attorney. And so our law students have the opportunity to represent live clients, to appear in court, and in some cases, help close the justice gap by providing representation to clients with fewer means or underrepresented clients. And the students do all this with a safety net because we, as the supervising attorneys who are barred, work very closely with the students on their cases every step of the way. My clinic, as you mentioned, is called the Holistic Youth Defense Clinic. We represent youth clients primarily between the ages of 13 to 17 who have been charged with felonies and misdemeanors. My law students work on the case from beginning to end, starting with the initial interview of the client, sometimes in detention if the kid's been arrested before the first court date. They request discovery from the prosecutor's office. They review all the discovery. They review all the police-worn, body-worn cam footage. They interview witnesses. They interview the caregivers of our clients. They research the charges and look for helpful case law. They negotiate with prosecutors by sharing mitigation information about our youths and their families and share helpful background information, and the students prepare for trials and hearings. For my third-year law students with practice certificates, they get the opportunity to represent our clients in court under my supervision. And our overarching goal for our clinic in every case is to try our best to keep our youth clients in their homes, in their schools, and in their communities. And we fight hard to achieve this goal. We also fight hard to keep kids from being felonized, which has lifelong consequences for youth, even in juvenile court. I'll also mention while the bulk of our work focuses on delinquency matters, delinquency is just a word we use for criminal and juvenile court. Because of my background as a former education law attorney, we also can sometimes assist our youth clients and their families with special education and school discipline matters, for instance, especially if resolving the school piece could lead to a more favorable outcome in court.
What a great opportunity for the law students to really learn while under the supervision and learn while doing. It's such an important thing, I would think. So thank you so much. Can you tell us about the kind of charges that your young clients of your clinic are facing?
So our clinic launched in 2001, and so we have been in existence for about 3 years. The vast majority of charges are things like larceny, auto larcenies, assault and battery for fights kids get into at school or in their neighborhood, charges of kids being in possession of stolen items, and occasional driving under the influence, and occasionally more significant charges like a breaking and entering when kids go into unlocked homes and take something that doesn't belong to them. And I don't want to downplay the distress and fear people face when they're victims of crimes, even non-person property crimes. My family personally experienced a burglary, and it really scared some members of my family and impacted them for a long time. And so I don't I don't, my intent is not to downplay these charges that my youth clients are charged with. But a lot of what I see in my clients is normative behavior for adolescents who are impulsive, subject to peer pressure, who make poor decisions in the heat of the moment to impress their peers or to not be excluded from a friend group, who have difficulties thinking about the consequences before acting, and who are egocentric still and don't think about how their action will impact the harmed party. So think of some of the behaviors and mistakes we made as children and teenagers. And I won't subject either of us to recounting some of those mistakes, but the research shows that the vast majority of court-involved kids who commit even serious crimes age out of their delinquent behavior by their late adolescence as their brains continue to develop, as they mature. And most of these youth age out of delinquent behaviors without significant court intervention. So I think it's important for us as a society to think about more effective ways to tackle juvenile delinquency and think about what is best long-term, not just for the community, but for the youth.
Great, thank you. Do you represent students in disciplinary hearings for charges that are referred to courts by the schools?
So the short answer is yes. The Holistic Youth Defense Clinic can represent students in disciplinary hearings at the school level for charges that schools refer to courts, as well as the court matter for when those charges are referred to courts. In fact, that was part of my vision when I first launched this clinic. I had hoped that my law students would be able to provide holistic representation by assisting clients on the civil matter, such as the school discipline hearing, and the criminal matter simultaneously. What I've learned since launching the clinic is that the school discipline process and the juvenile court process operate on different timelines. So often, by the time we're appointed on the delinquency matter in court for the school referred charge, the alleged offense in school could have happened over a month ago or more. And by the time my clinic gets involved on the delinquency side in court, the school disciplinary process has ended or is nearing completion. Occasionally, the school discipline timeline matches up with the court timeline or matches up more with the court timeline, or occasionally we're able to learn about the pending long-term suspension or expulsion early, and the clinic has been able to advise clients and parents on how to prepare for the disciplinary hearing, or we've been able to find pro bono counsel for our clients to help handle the school disciplinary hearing. But I would love to do more community outreach so that our local community is aware of our clinic services and use us as a resource. So instead of waiting for court appointments from the clerk's office, I would like families and stakeholders and community partners, and some of them do this already, but I'd love for more of them to reach out to us directly on the day of the school incident so that our clinic can get involved and then provide holistic representation from the start.
Okay, great. So you had mentioned a new organization to me, the Restorative Justice Program, that was launched by the Charlottesville and Albemarle Commonwealth Attorney's Office. Can you tell us about this organization and what are the issues they are seeking to impact and the services that you provide to youth in the area?
Yes, I'd love to talk about this program, but I'll give a little bit of background. So research shows that detention, which is a euphemism we use for incarceration in juvenile court, research shows that detention is not effective and is correlated with a host of negative outcomes for court-involved kids, including recidivism. I also want to note that when we jail kids, that interrupts their education, it interrupts their positive social bonds with their families, their teachers, and their pro-social peers. If they're working a part-time job, which is a pro-social activity and a necessary thing that we want kids to do, especially if we're expecting them to pay restitution for their offenses. They can get fired from their jobs, even if it's a short stint in detention. And so I want to start by saying, if we know that incarceration doesn't work for kids, we should be prioritizing alternatives to incarceration for the vast majority of our youth. And certainly for our youth, we're not dangerous. So there is a pretty famous judge in the juvenile court circles, a juvenile court judge named Judge Teskey, and he significantly revamped his juvenile court with the support of probation, prosecutors, defense attorneys, the schools, and the community by making a plan in his jurisdiction to reduce the number of petitions filed against kids and to prioritize filing petitions for serious offenses only. And he made a comment to the Washington Post that I'll share, something to the effect of, we shouldn't be incarcerating kids who make us mad. And I'll tell you that kids who make mistakes again and again, what some folks might call repeat offenders, they make adults mad. But we don't stop to think, why are we seeing the same kids again and again before this court? And I think sometimes we are willing to give an alternative to incarceration one chance, but if that doesn't work, we jump back to detention. But on the flip side, if detention doesn't work, so after a kid has served their time and they recidivate and commit another offense, we tend to try more detention when the kids come before the court again. And that's just not an effective solution for kids who are court involved or for the community. So with that being said, a possible alternative to court involvement and incarceration is restorative justice. Our local Commonwealth attorneys have, with the support of other stakeholders, have launched a restorative justice initiative called the Central Virginia Community Justice. And the program is currently being directed by two amazing directors, Aaron and Ashley, who are prosecutors. They're trained in restorative justice, and they run this program now. And so if a case is successfully referred to the Central Virginia Community Justice, the case is temporarily continued in court. That just means halted for several months to allow the restorative justice process to happen. And I'll talk more about the RJ process in a moment. I'll use RJ short for restorative justice. But ultimately, if the RJ process is successful and an agreed upon resolution is reached by the parties and completed by the person who committed the harm, the case is dismissed from court. And the youth is not entangled in a court process and not on probation for many, many months to over a year, as is often the case in the traditional court process. Now, I'll talk a little bit more about the actual restorative justice process. So in this process, the harmed party and the person who committed the harm, sometimes called the responsible party, and sometimes families are involved as well, meet with a trained restorative justice facilitator to discuss the harm, how the harm impacted both parties and their loved ones, and eventually how to repair the harm. The harmed party has a central voice in the process, and the person who committed the harm has to be fully accountable and face the person they harmed through their actions. This is the complete opposite of the traditional court process, when neither the complaining witness nor the youth defendant have any contact with each other. If, like in most cases, a plea bargain is reached in the traditional delinquency case going through court, the complaining witness may never come to court and never see the youth who committed the offense. And although most prosecutors likely tell the complaining witness what plea bargain was reached, the complaining witness may be left with questions like, why did this happen to me? Like, why was I targeted? Does the person who committed this harm know how this has impacted me, impacted my family? I think there's so many unanswered questions. From the youth perspective, I think it's incredibly difficult for a youth to take full accountability and have to face the person they harmed, as is the process in restorative justice. I think that takes incredible maturity, insight, and humility for youth clients to complete the restorative justice process at such a young age. I have had two youths who've been accepted into the restorative justice program here locally because case acceptance requires approval from the prosecutor and understandably agreement from the complaining witness. And both of my youth clients who participated in the RJ process successfully completed the process. And one of the youths had a fairly lengthy juvenile court history, had spent time in detention multiple times, had been on probation for lengthy periods, and on the matter my clinic represented him on, he was involved in a car larceny with older peers. They took an unlocked car and they went joyriding. And through the restorative justice process, my client got to know the person he harmed, who was a mom. And later he told me that this person was a really cool person. He learned how his actions impacted her, not just that day, but for weeks, because she was carless with a baby. And through the conferencing process, they reached an agreed upon resolution and even stayed in touch for a little bit by email after the final conference. And even though the harmed party suffered real harms and real inconveniences because of my client's actions, at the end of the process, this person encouraged my youth client to remember the lessons he learned and to help others going forward. And after the final conference, my client shared with me that he hopes every youth will have the opportunity to participate in restorative justice. And I hope that will eventually be the case here in our community, that both Commonwealth attorneys' offices automatically consider a referral for every delinquency case that involves a youth. And of course, the person who's harmed must agree to participate in the RJ process. But my hope is that the program will grow and every youth charged with a petition, be it a felony or a misdemeanor, has the opportunity to have their case considered for RJ. The Central Virginia Community Justice surveys each participant they serve, and 100% of their participants have responded agree or strongly agree to the statement, I am leaving the joint conference with a greater sense of well-being than before. There's a meta-analysis from 2009 that concluded that therapeutic programs for youth, programs that focus on skill building and restorative justice interventions have more impact on recidivism than the traditional surveillance, supervision, probation type model. And so restorative justice is just one alternative to incarceration, but I urge the society, our community, to focus more on effective alternatives to incarceration. And let's break out of our current cycle of punitive incarceration for our youths who make mistakes. Other alternatives to incarceration that we should consider are things like mentoring, counseling, art therapy, social services for youth and their family, community service, substance abuse treatment, probation if warranted, but only for the minimum amount of time to meet the probation goals. And probation should be tailored to the youth and focused on skill building, not overly focused on punishment. I think on the front end, we should focus on ways to reduce or prevent court involvement for youth by utilizing diversion. So that means even not referring the matter to court, but diverting it on the front end, dismissing it on the front end, perhaps with some counseling, perhaps with some referrals. And I think other ways to focus on reducing and preventing court involvement for youth is having a system in place that encourages law enforcement to refer kids to services rather than automatically filing a petition for lower level offenses. There's some research out of the University of California, Irvine that tracked the success of 532 youth who were arrested and referred to juvenile court for the first time. The researchers compared subsequent outcomes for youth who were diverted from court, so they didn't have to go through the court process, versus youth who were formally processed in court. And the study found that the diverted youth were far less likely to be suspended from school or rearrested. And the youth who were diverted from court self-reported far less reoffending behavior than youth formally processed in court.
Great. Thank you for that information. Such important programs and really great way to think about reform in this particular area. And finally, this is a big question to end on, but an important one. And you mentioned that you and your students often talk about the racial and ethnic disparities that you see in the criminal justice system. Can you tell us about the realities of what you are seeing in that regard?
Start by just sharing some national numbers. So Black youth were arrested at the rate of 2.6 times that of white youth in 2018. And though Black youth made up just 16% of the population of youth aged 10 to 17, this is in 2018, they accounted for half of all youth arrests for violent crimes that year and 42% of arrests for property crimes. After arrest, research shows that Black youths are more likely to be detained, prosecuted, and punished more harshly, even if they're charged with similar offenses and have similar prior histories as other youths. And although overall transfers of kids to adult court have decreased from 2005 to 2018. The racial disparities have increased, unfortunately. So in 2005, Black youth made up 39% of cases transferred to adult court. In 2018, though the overall number of transfers were lower nationally, Black youth made up more than 51% of transfers to adult court. So even though research shows that white youth are just as likely as Black youth to use drugs, carry a weapon, drink while driving, have unprotected sex, Black youth are more likely to be stopped, arrested, and punished for adolescent behaviors. And why is that? Well, my clients of color tend to live in over-policed communities. They may attend over-policed schools and are more likely to engage in adolescent behaviors on street corners than white youth who may be able to do so in the privacy of their homes. My clients of color are more likely to have police encounters, which can lead to arrest and court involvement. My law students have reflected on the jarring experience of going into the courtroom and seeing predominantly all white faces on one side of the court. The judges, the lawyers, the court personnel, the sheriff's deputy, all the people in power. And then on the other side, you often see all people of color, our youth clients, their families, their baby brothers and sisters, their loved ones. And what we strive to do in our clinic is to present a holistic view of the kids we represent to the prosecutors, to the probation officers, and to the court. Because without additional information, the prosecutors and judges have limited information. All they see is the offense, which is usually the worst thing our client has done in his life. And if we don't get to know our clients and we don't share what we've learned about their family history, their background, their trauma history, their future goals, if we don't learn those things and share those things with the people in power, prosecutors and judges won't know that our kid is on track to play Division I football, or our kid helps take care of his ailing grandmother or his younger siblings at home while his single parent works 2 jobs. Or they won't know that our youth client is working 20 to 30 hours a week to help their family pay bills, or that they've been struggling in school for years because of an unidentified disability that should have been caught early enough to receive special education services. I think it can be hard to see kids as kids when they commit offenses that seem to us like very adult offenses, offenses with guns, offenses that could put bystanders in danger. And while it's hard to do, I urge everyone to see kids who are court involved as your own kids, regular kids who've made the biggest mistake of their lives. What would you want for your kid if this had happened to them? They had made this big mistake. You wouldn't want them to lose their childhood. You'd want to give your child every chance to make amends, rehabilitate, and learn and grow from this mistake. My spouse is a prosecutor, and I've often said to him, I wish every prosecutor and judge would spend one night in a juvenile detention facility. And actually, I say, scratch that. I wish their kids could spend a night in a juvenile detention facility so they can experience firsthand the trauma of having their kid incarcerated in a locked facility, starting from arrest, when kids are sometimes thrown to the ground and shackled with handcuffs by multiple law enforcement officers, searched aggressively, strip searched prior to entering the detention facility, and spend the night in detention away from their loved ones. Who'd want their child to be subjected to that kind of treatment? I have a child now, and I am horrified at the thought of my child being caged. But I think until we see the kids in the community, those kids as our kids, I fear that significant reforms in the juvenile legal system will not happen.
Great. Well, thank you so much, Professor Shin, for sharing this information about the important work being done by you and your students at the Holistic Youth Defense Clinic. You and your colleagues are doing such important work. And I appreciate you sharing your knowledge and expertise with UVA's alumni, friends, and families. So thank you so much.
Yes, absolutely. I know I speak for my law students and myself when I say it's really a privilege to serve the youth and in our community, youths in our community and their families. And we are thankful for the privilege to be able to be an advocate for them.
Great. Thank you so much. And thank you to everybody for listening. For upcoming podcasts and other lifetime learning programming, recordings, and blogs, please visit our website at engagement.virginia.edu/learn. You can also find our podcast on the Virginia Audio Collective, which is a network of UVA podcasts hosted by WTJU Radio and can be found at virginiaaudio.org. So thanks again, and we look forward to you taking part in future lifetime learning programs.